예, 그러면은
We will now start.
오늘의 마지막 세션이
Last session of today, session 3.
3세션에서는
And
의학
here
및
we will
생명공학 발명의 주요
look
이슈에
into
관해서
the emerging issues on pharma and biotech invention, moderated by Honorable High Court Judge Sung Woo of the IP High Court of Korea. Please welcome our moderator with a round of applause.
네, 안녕하십니까.
Afternoon. I'm Judge Sungyop of IP High Court of Korea, and I'll be your moderator for
생명공학 관련 발명은 우리 시대 과학적,
technology, which will be the theme of this session, are at the core of scientific and medical progress of
치료법의 발전뿐 아니라 삶의
advances in disease diagnosis and treatment, as well as improving our quality of life. These inventions also play an important role in patent disputes and are directly related to competitiveness in the global market.
각국의 저명한 판사님들과 함께 중요한 주제에 대해
To discuss this important topic, and I look forward to very fruitful discussion. Now, before we get started, I will introduce the panelists of session 3 in alphabetic order of their family name. Please welcome them with a round applause. First, we have Judge Kenji Amano on my left from Japan. Then we also have Presiding Judge Lei Fu of the Supreme People's Court of PRC. Then we have Judge Maximilian Haedicke, UPC, from the UPC, Paris Central Division. Also, we have Circuit Judge Kent Jordan from the U.S. Court of Appeals for the Third Circuit. And we have returning panelists from session 2, Judge Richard Meade of the High Court of England and Wales. Lastly, we have Judge Jiyoung, High Court Judge of the IP High Court of Korea. So I'll just call you as judges during this panel discussion, and they have already given us experts and detailed written response to the topics, which are included in the reference book. And due to time constraint, we may only be able to present or respond to highlights. So we ask for your understanding in advance. And if you want to, read all the details, please refer to the reference book or the booklet. This session is organized into two parts. In the first part, each panelist will give a 10-minute presentation using the prepared PPT on the latest issues related to the topics that we are going to handle in this session. Then in the part 2, we'll hear answers to the questions sent from the panelists by country and discuss the legal system and practices in their respective countries. So in this slide, you can see the field of medicine biotechnology inventions is globally connected, and disputes over a single patent invention can arise in many countries. So it is very necessary and meaningful to review and discuss comparative legal cases in different countries. Now, we will listen to the presentations, and again, in the alphabetic order of the family names of the panelists, and I would like to ask everyone to comply with the 10 minutes constraints of each presentation. And we'll start with Japan. Judge Kenji Amano is going to talk about the pharma and biotech inventions on Japan. So please, you have the floor.
Okay. Thank you. Talking about pharmaceutical invention is a very difficult task for me, but I will do my best. Today, I will introduce two Japanese patent cases. First one is regard to secondary use inventions, and the second case about polymorphs. Okay. When we discuss secondary use invention, one of the most controversial issues is whether or not disclosure of such use is in the specification is enough. Like other nations and areas, Japanese Patent Act has some requirement for the description of the specification. One of those requirements is called support requirement. Basically, it requires the applicant to state the claimed invention into the detailed explanation part of the specification. The basic idea is that substantial part of the claimed invention should have enough basis or support in this specification. Okay. Of course, this explanation just technically copying the claim and passing to, one of the leading IP High Court case in 2005, describing here, held that whether or not the claimed invention is stated should be determined by looking both claims and descriptions and considering whether the skilled person in the art could understand that the claimed invention would solve the problem. That's the general rule. Okay, so let's step forward to today's first case. This is one of the famous global patent disputes by patent holder Warner Lambert about the second use invention of pregabalin or Haedicke. One of the corresponding patents is written below, EP 09346061. This is a very famous case, and maybe Justice Meade will explain later. But the gist of the case is the pregabalin is existing known compound, and the claimed invention are: 1. Use of pregabalin for treating all types of pain, and 2. Use of pregabalin for treating neuropathic pain. However, as UK Supreme Court holds, there was not enough scientific reason in this specification with regard to neuropathic pain. On these circumstances, IP Court held that the claimed invention did not satisfy the support requirement because the lack of description hampers the understanding of the skilled person in the art how the inventions would solve the problem, in this case to treat all type of pain. Some of IP High Court decision held that this is the issue of enablement. I think both are okay, since support requirement and enablement requirement is asking similar thing to the applicant. Anyway, this decision held that the claim invention is not supported by description. Okay, move on to the next case. Okay, polymorphos. I have to admit that the past several years, IP High Court of Japan had been relatively strict for inventive step of polymorph invention. The arguments are follows, the reasons are follows. Especially for pharmaceutical compounds, crystalline forms are superior than amorphous in several aspects. And for the skilled person, polymorphism screening of known compounds some kind of routine, and they would have a clear expectation to get improved product by this routine. There is a motivation for skilled person to routinely try and error to get improved polymorphs. So it has been hard to get patent for polymorphs inventions. However, there are some exceptions. One of those is this case. So in this case, claimed invention was the crystal forms of straphyrin, which have I can read my particular particle size on crystallinity. However, other crystal form of this compound was known as prior art. For that case, court held that the claimed invention has an inventive step. Why? Because the problem to be solved by the invention was the balance of solubility and stability, which is not realized in prior art. And there was a common knowledge that when skilled person raised crystallinity to improve stability, it hampers solubility. There was a trade-off. So there was technical obstacle to get the claimed form of this compound. And the data in the description showed an unexpected advanced technical effect. Those were reasons by the court. So to sum up, in order to get polyforms invention patented, applicants have to show both difficulty to get that form and its technical effect. I think this approach is very similar to other nations and areas, including Korea. Finally, this is my sort of advertisement. This is a nice time to introduce myself. I am a triathlete, and one of my dreams is to participate in Ironman race in every single continent except Antarctic. So we will meet again in anywhere in the world at Ironman race. Thank you for your attention. Okay.
네, 아마노 판사님 감사드립니다.
Well, thank you so much. Now, you present two very interesting case, Warner Lambert, a case I believe Judge Meade would also talk about this. And as you have heard, in the UK, it failed to meet the sufficiency requirement, but in Japan, it did not meet the supporting claim. So maybe we can compare that. And in terms of crystalline, inventive step was recognized, and I believe in Korea, we will also talk about inventive steps, so we could also compare that against the Korean case. Thank you very much. Now we will move to China.
최근 중국 특허법의 개정에 따라 도입된 의약품 특허 분쟁의 조기 해결 메커니즘.
So,
의약품 특허
Lei Fu from China will be talking about China's pharmaceutical patent linkage litigation practice. Ms. Fu, please go ahead.
Okay, thank you. Good day to everyone. An honor to be invited to this conference. Today, I will focus on China's pharmaceutical patent linkage litigation practice. My presentation will cover four main points: the importance of the system, the pertinent laws and judicial interpretations, an overview of its judicial practice, and finally, some typical cases in China. The field of pharmaceuticals and biotech is one of the areas with the highest technological content and most active investment. It's a key sector promoting public health and safety, and an essential area that China's patent judicial practice have been emphasizing over the past 2 years. To promote resolution of pharmaceutical patent disputes, China has recently established a system called Pharmaceutical Patent Linkage System. Moving on to its legal sources, the Pharmaceutical Patent Linkage System was introduced to the China's patent law through its fourth amendment in 2020, specifically in Article 76. This system sets up an early dispute resolution mechanism for pharmaceutical patent disputes. Under this framework, the originator pharmaceutical company is required to accurately register its pharmaceutical patent information. While the generic drug company must submit one of the 4 kinds of declaration. In particular, for the 4 kinds of declaration, if the patent holder or originator drug or a stakeholder has objection, they can either file a lawsuit in court or request administrative adjudication from the Patent Administrative Department. This process then triggers pharmaceutical patent linkage litigation. To ensure proper adjudication of these civil cases, in 2021, the Supreme People's Court issued a judicial interpretation. This interpretation provides clear guidance on key issues, such as the competent court, the course of action, and the principle of res judicata of the cases. These measures are designed to facilitate the substantive resolution of early disputes regarding pharmaceutical patents. Now, let's shift our focus to its real-world application. Since November 8, 2021, the SPC has accepted 37 civil second-instance cases related to pharmaceutical patent linkage and has concluded 31 of them. For a few key cases that exemplify its implementation, firstly, I would like to highlight the case, the Chugai company with Wenzhou Haihe company case. In this case, the plaintiff held a patent for an originator drug, while the defendant applied for a generic drug that made a 4-time declaration, claiming that the generic drug did not fall within the scope of the originator drug's patent protection. In response, the plaintiff filed a lawsuit with Beijing IP Court, seeking a ruling that the defendant's generic drug fell within the scope of the patent in question. The Beijing IP Court found that before the defendant submitted the 4-time declaration, the plaintiff had amended the Claim 1 during the administrative procedure. Initially, Claim 1 does not specify the selection of antioxidants, but after the amendment, the plaintiff abandoned 3 of the antioxidants, retaining only 1. Notably, the antioxidants used in the defendant's generic drug happened to be one of those 3 that the plaintiff had given up. The Beijing IP Court held that, firstly, the antioxidant used by the defendant differed from the specified in the plaintiff's amended Claim 1. Secondly, regarding the doctrine of equivalence, since the antioxidant used by the defendant was mentioned only in the patent's specification and not in the claims. It had been dedicated according to the doctrine of dedication. This doctrine served as a limitation on the doctrine of equivalence, meaning one cannot evolve the doctrine of equivalence to reintroduce a deleted technical scheme back into the scope of protection. Consequently, the court determined that there was no equivalent infringement. Ultimately, the Beijing IP Court concluded that the generic drug did not fall within the scope of the plaintiff patent. The plaintiff appealed to the SPC, which ruled that, based on the principle of estoppel, the plaintiff had abandoned the other three antioxidants during the prior patent invalidation procedure and could not now claim equivalence in this case. Therefore, the SPC upheld the first instance judgment. Additionally, the court criticized the defendant for failing to meet the obligation of declaration and notification related to generic drugs. As the time is running short, so I regret that I cannot continue with more typical cases. To conclude, Chinese courts highly emphasize balancing the interest of originator and generic drugs, focusing on the substantive resolution of conflicts within the pharmaceutical patent linkage system, and drawing from international experience in pharmaceutical patent protection. We look forward to sharing insights, fostering collaboration, and working together with countries worldwide to enhance and advance the pharmaceutical patent linkage system. Thank you all.
Well, thank you very much. We heard about the China latest patent dispute resolution system, talked about the law as well as actual cases. Thank you so much. We will now move to Europe, and Vice Judge Haedicke is going to talk about first case issuance for preliminary junction. And also new standards and procedure that's related to inventive step and any UPC case related to that. So please go ahead.
Thank you very much, and let me start with a few personal remarks. First of all, yesterday I visited Seoul, and I was very impressed about how well organized, how smooth, how friendly, how efficient everything is. I'm just used to be in Berlin, so things are quite different here. And so is the conference. It's well organized, it's high level, it's friendly, it's professional. I really enjoy being here. I want to thank you very much for having me here. Secondly, I learned that this conference celebrates a birthday, a 10th birthday. I personally can also celebrate a birthday because yesterday, the first two judgments of our panel of the Paris Central Division were issued about vaping devices. So we issued after 50 months of the court our first judgments. It feels really good to have the first judgment out there. Thirdly, this court is around for 15 months now. Some people call it a baby. I don't know if that's true because you would not trust your pharmaceutical patents to a baby. But I think this baby can start to work now. It grows, gets smarter, and we hope it's a prodigious child. Mozart wrote his first major works with 5 years. We started with the first year, so we are very optimistic, even though we cannot compare our work with eternal music. it's always good to have a role model. Then fourth, I want to apologize for submitting nearly 30 slides, which is far too much for a 10-minute or 8-minute presentation now. It's indolence if it's even worse when one considers the fact that the UPC has until now only decided 2, or you can say 3 major cases in the field of pharmaceutical patents. So please excuse me when I sum up something and skip some slides. Needless to say that I express my own personal opinion and I do not speak for the court. As already said by Judge Carlton today, there were a certain reluctancy to trust pharmaceutical patents, the crown jewels of the pharmaceutical industry, to the UPC. There were some questions. Just find this. Who will be the judges? Will the UPC be patent friendly, whatever that means? And then, of course, what standards will they apply? Will they apply the EPO principles of patentability, or will they make up something different? In the remaining time of my presentation, only 7 minutes, I will introduce 2 major cases which UPC issued in this field of pharmaceutical patents. I will try to at least hint an answer to these questions. First case I want to talk about is nanostrings against 10x Genomics. It concerns compositions and methods for analyte detection on a cellular tissue sample. Sounds complicated, it's complicated. The Court of Appeal overturned the decision of the Munich Local Division and set aside the PI. The Court of Appeal has clarified that a sufficient degree of certainty requires that the court considers it at least more likely than not that the applicant is entitled to initiate proceedings and that the patent is infringed. A sufficient degree of certainty is lacking if the court considers it on a balance of probabilities to be more likely than not the patent is not valid. In the case, the Court of Appeal considered the standard not to be satisfied. Without diving deeply into the facts of this case, it suffices to say that the court found that the skilled person would have considered certain documents which are close to the invention, and the skilled person would also have considered to transfer certain analyzing techniques. Therefore, the Court of Appeal decided it's more likely than not that a patent at issue will be proved to be invalid in proceedings on the merits due to a lack of inventiveness. Hence, there was no sufficient basis for the issuance of a preliminary injunction. I will now talk about the second case, and I did not say anything yet about the standards applied by the court to identify an inventive step. I will discuss this in connection with the second case I want to introduce. This case concerns a revocation action before the Munich Central Division between Sanofi and Amgen. The patent held by Amgen concerns an active ingredient called evocumab, a cholesterol-lowering drug. Besides claim interpretation, the Central Division had to deal with the requirements of an inventive step. Leaning on the appeal decision in the previously described nanostring case, the Central Division identified some basic rules for determining the inventive step. First, whether there is an inventive step is to be assessed in each individual case and requires legal evaluation of all relevant facts and circumstances. Secondly, an objective approach must be applied. Subjective ideas of the applicant are irrelevant. It's also irrelevant whether the invention is the result of systematic work. It only matters what the claimed invention actually contributes to the prior art. And the inventive step is to be assessed from the point of view of a skilled person on the basis of the state of the art as a whole, including a skilled person's common general knowledge. So that means that the Munich Concept division identified the following test. First, identify a realistic starting point in state of the art. Then compare the claimed subject matter and prior art to determine whether it would be obvious for the skilled person to arrive at the claimed solution. What is most important, I think, is that by applying this test, the Munich division did not strictly follow the EPO's problem-solution approach. Instead of identifying the closest prior art, it said that a realistic starting point was required. A starting point will be considered realistic if its teaching would have been of interest to a skilled person who was seeking to develop a similar product to the disclosed in the prior art and therefore had a similar underlying problem as a claimed invention. There has to be such justification as to why the skilled person would consider a particular part of the state of the art as a realistic starting point. There's not one exclusive starting point to be identified, but there can be several starting points. What matters is that the CD concluded that using the starting point, the person skilled in the art would pursue the route of developing antibodies, thereby arriving at antibodies as defined in the claims without inventive skill. And the CD also considered it to be relevant that the priority date of a significant commercial interest in the target for the treatment of hypercholesterolemia. The take-home point of this judgment, hold on, I'll skip all the details here. The take-home point is that two steps are required for the examination of the inventive step. First, find a realistic starting point. Secondly, the claimed subject matter and the prior art are compared to determine whether it would be obvious to the skilled person to, starting from a realistic starting point, arrive at the claimed solution. Let me add that after I finalized my preparation for this conference, another case was decided by the Munich Central Division, which concerned a patent closely related to the first nanostring case. And the Central Division, which is no surprise, revoked the patent due to the lack of inventiveness. Let me finish with trying to give you some answers to the questions I started off with. First question was, who will be the judges? The judges of the UPC are, with very few exceptions, judges of the national courts. The judges have been elected with a view to their competency and not by applying political considerations. Secondly, will the UPC be patent friendly? My answer is, of course, we are no anti-patent activists, but apart from this, we're neither patent friendly nor patent unfriendly. We just apply the law and, when necessary, contribute to the further development of the law by taking into account all interests. Third question, will they follow the EPO principles on patentability? It's too early to say that. I cannot answer this question, at least for now. It can be said that the UPC has not clearly announced that it follows the EPO law. The UPC, to start again with what I said in the beginning, starts to walk, and we're very optimistic that it gains confidence by the patentees. Also in the field of pharmaceutical patents, we do our best, and the toddler speaks German and English. Thank you very much for your kind attention.
예, 감사드립니다.
Thank you so much.
그러면 이어서
Now we'll move our, we'll go to the US.
PPT를 준비해 주셨습니다.
So he has come with the presentation material. So he's going to look at the Spring Courses Amgen versus Sanofi case, where they look into the enabling requirement and also about the obviousness, and if time allows, latest legislative trend of the US Congress. Please.
I want to second everything that Judge Haedicke has said about the conference. It's beautifully organized, so I'm just so grateful, just really thankful to be part of this, and honored to be here. It's election day back in the United States, so I'm grateful to be anywhere except the United States. It's a little crazy back there right now. I'll speak about the U.S. perspective, as was just mentioned, on some issues, but let me just say that in American football, when a quarterback sees something developing on the field, he'll do sometimes what's called calling an audible, which means changing the play. So I'm calling an audible, and given the hour and the amount of time I have, I thought I probably won't discuss the issue of obviousness type double patenting. In the spirit of Judge Kim's confession to conversations over the doctrine of equivalence with lots of alcohol, I'm afraid I might drive you all to drink if I started talking about obviousness type double patenting. So instead I'm going to focus on the Amgen versus Sanofi case, and then I will talk a little bit about three pieces of legislation that are pending in this Congress, and which probably are not going to get past this Congress, but I think have some fair prospect in the Congress to come. So, turning to Amgen, I begin by echoing something that Justice Scalia of the U.S. Supreme Court said when he concurred in a biotech patent case, and basically stated, "I'm concurring because, frankly, I don't understand the science." He had enough self-awareness to step up and say, this is very hard stuff. And I'm not like my great colleague and friend here on the dais, Judge Yi, who's got a doctorate in pharmaceutical sciences. I'm a generalist judge who just loves patent cases, and when it comes to biopharma cases, I feel like I really have to get my nose to the grindstone to understand the science. Amgen is versus Sanofi involved biologics, and that's one of the hardest, I think, of the biopharma kind of cases to deal with. I note that for all the eager anticipation leading up to the Supreme Court's decision in 2023, when it finally came to it, the Supreme Court described its ruling as just a restatement in the biopharma context of what it had said about the enablement requirements on many past occasions. Namely, that if a patent claims an entire class of processes, machines, manufacturers, or compositions of matter, the patent specification must enable a person skilled in the art to make and use the entire class. Now, Amgen was not a case brought under the traditional way that we typically think of biopharma cases coming up in the United States. It wasn't a Hatch-Waxman case. It wasn't even a case brought under the Biologics Price Competition and Innovation Act, the BPCIA. It was brought under traditional patent statutes. But I do want to take a moment to talk about the BPCIA, because that statute was passed in 2010 as a way of providing an abbreviated path to approval of biosimilar products. It would be akin to the path available for so-called small molecule generic drugs under the Hatch-Waxman Act. My dear friend, Judge Rader, I think was probably around in Congress or when they were drafting the Hatch-Waxman Act. And that was the product of very careful legislative balancing of multiple constraints and political concerns. And the biosimilars, the BPCIA, is a similar effort. Without getting too far into the regulatory weeds or into the science, which, as I already said, would put me instantly out of my depth, suffice it to say that while the analogy is not perfect, biosimilars are biologic treatment products are to biologic treatment products as generic small molecule drugs are to traditional name brand drugs. The big difference is that whereas a generic small molecule drug can be an exact replica of the name brand, a biosimilar can be highly similar to the reference product, but it will never be exactly the same because the complex proteins in biological products are not subject to copying in the same way as small molecule drugs are. This has ramifications when one comes to questions of patentability of the reference product, because although there have not been as many, not nearly as many, biosimilar cases, at least not relative to Hatch-Waxman cases, one issue that seems to predictably come up in those cases, as it did in Amgen versus Sanofi, is enablement. If you know the case of Amgen versus Sanofi, you'll remember that Amgen sued Sanofi for infringing a couple of patents that Amgen had obtained on antibodies that affect the level of so-called LDL cholesterol. That's the bad cholesterol that contributes to risk for heart disease and stroke. The suit was brought in my home district of Delaware, which, as you've heard already mentioned in this conference, sees a whole lot of patent cases. And while my usual gig is on the Third Circuit Court of Appeals, I sit regularly as a judge of first instance in the District of Delaware so that I can continue to keep my hand in patent cases. And one of my colleagues handled this on the district court. The patents claimed a genus of antibodies affecting the PCSK9 protein. In other words, as the court put it, the PCSK9 is a naturally occurring protein that binds to and degrades LDL receptors. And that can pose a problem because the body produces LDL receptors specifically to perform the beneficial function of getting rid of LDL cholesterol from the bloodstream. So in the claims at issue in the case, Amgen did not seek protection for any particular antibody described by an amino acid sequence. Instead, it purported to claim for itself the entire genus of antibodies that bind to specific amino acid residues on that particular protein and block that protein from binding to LDL receptors. And that presented a problem. I'm greatly simplifying here in the interest of time and my own limited knowledge, but the problem was, given the variety of permutations that the antibodies could manifest, there could be millions of them that fit the parameters of the broad claims in the patent. This sort of patent claiming typically is, you know, I'm gonna focus on the antigen that's the target of the antibody. I'm gonna focus on the function that I want this antibody to perform and where it's going to perform it on the protein. And I'm going to then claim a broad genus kind of a claim against all the antibodies associated with that. And that's what Amgen did there, but it provided only 26 examples of specific antibodies. Without putting words into the Supreme Court justices' mouths, I think the justices saw this basically as if someone tried to claim 1 million acres of land with a deed describing just 26 acres. The Federal Circuit had looked at the dispute and held the asserted claims were not enabled, and the Supreme Court agreed with them. It said that, quote, the specification must enable the full scope of the invention as defined by its claims. The more one claims, the more one must enable. That principle was brought to bear again in a case just last year in the Federal Circuit called Basalta versus Genentech. It was another antibody case, and the court there observed that the facts were materially indistinguishable from those in Amgen. So it's not surprising that the outcome of the case was the same, since there were, quote, millions of potential candidate antibodies and the written description disclosed only 11. The court then held that the claims were not enabled and hence were invalid. As the Federal Circuit put it, it is undisputed that to practice the full scope of the claimed invention, skilled artisans must make candidate antibodies and screen them to determine which ones perform the claimed functions. Under Amgen, such random trial and error discovery without more constitutes unreasonable experimentation and so falls outside the bounds required by written description. So that's that. Now, in the no time I have left, I'll mention these three patents, potential pieces of litigation, because they could be important in the U.S. and perhaps to other countries as well. The Patent Eligibility Restoration Act aims to resolve uncertainty over patentable subject matter. It's been an object of a lot of dispute and argument in the United States, what can and can't be covered by patents, ever since the Supreme Court's decision in Mayo Collaborative Services, a biopharma kind of case, by the way. So that would be a big deal if they manage the Congress to tackle this, because the Supreme Court won't. Second, there's the so-called Prevail Act, which, according to the legislation, would do a number of things to alter how the PTAB, the Patent Trial and Appeal Board, operates, including making some standing requirements in that body which have not existed before now. That is, standing to bring a post-grant or IPR challenge. And finally, maybe most dramatic, the Restore Patent Acts case, or Act, which would essentially do away with the Supreme Court's decision in eBay versus Merck Exchange, which overruled the long-standing precedent establishing a presumption for injunctive relief upon a finding of infringement of a valid patent. That would be a very significant step, and it has strong bipartisan support, and I'm hopeful that it passes. Thanks very much.
예, 조든 판사님, 예, 감사드립니다.
Thank you so much for the presentation. We'll now move to the next presentation, which will be from Judge Meade, and he's going to talk about insufficient requirement, inventive step requirement, and cases in the UK law related to plausibility dispute related to this requirement. Please go ahead.
Thank you very much. Could you put the slide up, please? Thank you very much. So I'm going to talk about the law of plausibility in European patents, both from the perspective of UK law and from the perspective of EPO, European Patent Office case law. And I'm also going to talk about the way in which our courts in the UK try to follow the case law of the EPO, where it establishes new principles or where it changes established principles. The law of plausibility in European patent law isn't exclusively applicable to the pharma field, but that's where it really has its effect, and that is where it is of topical interest. So I'll start with the case of Warner-Lambert and generics from our Supreme Court in 2018. And this is the equivalent case to the case in Japan that Judge Amano discussed already. And it had the same result as was achieved in Japan, as I understand it, for very similar reasons. It was a second medical use claim for the use of the known drug pregabalin in treating neuropathic pain. And on the facts that the trial court had found, the patent said that pregabalin was useful for treating neuropathic pain, but it didn't contain any evidence, any reasonable evidence anyway, that that was in fact true. And the question for the court, and in due course the Supreme Court, was whether or not that rendered the patent invalid. For reasons I'll come on to, our Supreme Court in that case reviewed all of the European Patent Office case law on this topic, and it opted for what at the time was called the ab initio plausibility test. And that was one of three tests that had been considered by the European Patent Office over the several years before that decision. And what the ab initio plausibility test means is that where a patentee seeks to rely on a particular effect, in this case the use of pregabalin to treat neuropathic pain, then in order to rely on that effect, either for the law of inventive step or for the law of sufficiency, the specification has to contain some reason to think, some evidence-based reason to think that the effect is in fact achieved. The Supreme Court said that it was a low hurdle, an easy hurdle to clear, but that there had to be some reason to think the effect was true, and that could be based either on some simple experiment such as an animal model, or it could be based on a rational theory, even in the absence of some experimental material. So that was the situation in the Supreme Court decision in the UK. The next important event was the decision by the enlarged board of the European Patent Office. Goes without saying, I'm talking here now about the European Patent Office and not the UPC, in the case of G2 of 21. And the enlarged board of the EPO is the European Patent Office's ultimate court, the highest court of appeal. It hears only a few cases, it hears only the most important cases, and it can take cases either because a lower court refers them or because the president of the European Patent Office refers a case for decision. The decision in G2 of 21 was mainly a case about inventive step, which is decided for us under Article 56 of the European Patent Convention. But it contained obiter comments, in other words, comments that weren't essential to the decision, about insufficiency, which arises under Article 83 of the EPC, and especially insufficiency of second medical use claims. And the case appeared to treat insufficiency differently from inventive step. The court said in its decision that plausibility was not a separate legal concept recognized by the European Patent Convention. And in fact, the UK Supreme Court had said the same thing in Warner-Lambert and the pregabalin case. And it went on to say, the enlarged board that is, that inventive step is essentially a disclosure test so far as the EPO is concerned. And what I mean by that is that it is sufficient for a claimed technical effect to be taken into account for the law of obviousness, that the effect is disclosed in the patent application, even if the patent application doesn't contain any evidence to justify thinking that it's true. In other words, it's enough for the patentee to say that the effect exists. In respect of second medical use cases, in its obiter comments, the enlarged board said that where a technical feature is recited in the claim of the patent, which is typically the case with second medical use patents, then there does have to be some reason in the specification to consider that the effect is truly possessed. So that was the position from the case law of the EPO following G2 of 21. And you will have noticed, I'm sure, that there was a potential difference between the EPO case law and the UK case law, at least in respect of inventive step. So the next question for us in the UK is, how should we proceed in the light of EPO case law? And I've put 4 propositions here. First of all, the UK courts will normally follow the settled case law of the EPO, and certainly a decision of the enlarged Board of Appeal is the settled case law of the EPO. However, second point, the UK courts apply the doctrine of precedent. The UK Court of Appeal has decided that it can depart from the effect of its own decisions which would normally be binding on it, in the event of later EPO case law which is different. But it's been decided by the UK Supreme Court, only the UK Supreme Court can depart from its own decisions in the event of later EPO case law. So until our Supreme Court reconsiders Warner-Lambert and the pregabalin case, that will be a binding decision for us. Next, the Court of Appeal had to consider how to apply these propositions in a case called Sandoz and Teva against BMS, which concerned a drug called apixaban. I think Judge Calden mentioned it earlier. And the Court of Appeal, in the context of a single molecule claim, held that there was no need to change from the Supreme Court's case law in Warner-Lambert. Indeed, of course, the Court of Appeal wasn't free to do that because Warner-Lambert was binding on it. And following a further detailed review of the EPO case law, the Court of Appeal in apixaban said that the EPO decision in G2 of 21 was rather the same as ab initio plausibility, which I think later cases in the EPO itself has turned out to show was not correct. But the Court of Appeal was making these statements at quite an early stage. So the Court of Appeal held that the patent was invalid. A different decision has been reached in the Netherlands and indeed a number of other European jurisdictions, and that's why this remains such an important topic. Just to emphasize, it wasn't a material difference between apixaban and Warner-Lambert that there was a claim to a single compound. That was the same in both cases. And in the apixaban case, the Court of Appeal had noted that the parties had said that the case would be decided the same way, whether it was decided for inventive step or insufficiency. And that is doubtful now in the light of G2 of 21, but the Court of Appeal couldn't depart from the way in which the parties had agreed that the case ought to be decided. The Supreme Court, for us, refused permission to appeal in that case, to the surprise of quite a lot of lawyers in the field in the UK. But it is the Supreme Court's own decision in the UK, and only the Supreme Court's decision, what cases to take on appeal. And it's widely thought, and I agree with this, that the Supreme Court in that case probably thought that the decision was too fact-specific and not the right occasion for them to reconsider the law in general. So for us, the important questions that we will have to face in the near future are these. First of all, when the UK Supreme Court comes to consider G2 of 21, as I'm sure it will, because it knows it's the only court that can change UK law, what will it do? Second, how can speculative claims be policed? And what I mean by a speculative claim is a claim where a patentee in fact has no reason to believe that an effect is true, but simply asserts that it's true and uses that as the basis for a claim. It's unclear in the light of G2 of 21 how those situations should be controlled. Thirdly, and relatedly, how should the law of insufficiency under Article 83 of the EPC be assessed in the light of G2 of 21? That's an open question for reasons that I discussed earlier in touching on that case. And fourthly, also importantly, should it matter to the law of insufficiency whether the technical effect is actually recited in the claim or not recited in the claim but relied on in the specification as the basis for patentability? So this is a fast-changing area. There will certainly be new case law to come from the UK, and I suspect the European Patent Office, probably the UPC as well in the near future, and I look forward to seeing what is decided by those courts. Thank you very much.
예, 미드 판사님.
Well, thank you very much, Judge Meade. Next, we'll move
일부의 마지막으로
to the
이지영 판사님의 순서입니다.
Judge Jiyoung's presentation is going to look at the Korean cases where they look at the sufficiency requirement and inventive step requirements.
환사입니다.
Hi, this is Jiyoung. I don't have not much time, so I will just focus on a few cases. And before I move on to the cases, I would like to share my personal thoughts. As you can see from my CV, before I studied law, I studied pharmaceutical area, and back in the days I thought that I would be saving the humanity by studying the pharmaceutical area, and I did go through the master's and the doctoral degree, and the imitative, in its development, I did make contributions and efforts towards it. But then as I became the judge, ironically, I am killing a lot of the pharmaceutical patents. So this is a very ironical situation. But in one other way, the civil judges and the criminal judges, they are always thinking about, maybe they're harming one's lives. And then when the judges deal with the patents, maybe we are, killing or making a decision on the, drugs that may be saving, a lot of lives. So we are always trapped in this very serious question in mind, and we, I believe, are sharing the same kind of a difficulty in that sense. And let me start my presentation with that note. And when it comes to the Korean context, when it comes to the enablement, I am sure that many of you are very well aware of this concept, so I'll be just touching upon really just a few points. And when it comes to the pharmaceuticals, the mechanism of the drug is the most important, and if it is clear, there's no problem. But then if it is not clear, then the examples will need to be provided, or experimental examples will need to be provided. And in the specifications, you cannot supplement it afterwards, so this is rather strictly looked at. So when it comes to the data that can be substituting that can be supplemented by the experimental data, what would that be? That could be encompassing both the qualitative and quantitative aspects. And the UK and US's plausibility, just like that, we are not only looking at we are not including all of that aspect in the Korean context. We are still having some disputes around whether to include that aspect or not. But then I think I can give you the Abilify case as an example. As you can see, the first, medical use was the unipolar depression, depression. But then the depression from the bipolar disorder, can that be also treated using this medicine, is something that was at issue. And the Supreme Court looked at the drug mechanism as a starter, and if there is no such information, they looked at the data of the medical pharmacological data, and it also looked at the pharmacological effect. And as mentioned earlier, the unipolar depression and the depression from the bipolar disorder are two different diagnoses, and the treatment methods are different. So even when you have the effect that is verified for the first one, it doesn't mean that it can be applied to the second one. So they are diagnosed and treated differently. So that was not specified in the specifications. So even if you don't have the pharmacological data, maybe there could be some description that could be, substituting such description, and there was none. That is why the patent was rendered invalid in this case. And when it comes to the medical use inventions, maybe the bar seems to be very high, and that may be the criticism that many judges receive. But then this area requires further academic research. And let me move on to the inventive step. And as for the inventive step, as you can see, we have the definition set out in the Article 29.2 of the Patent Act. And when it comes to the inventive step, the Supreme Court have made multiple rulings related to it, and I have quoted in the page. So based on this kind of a criterion, if the FUSITA can form the item with the prior art, and if that can be made easily and if the same effect can be achieved, then that would be the inventive step requirements that will need to be looked at. And there are two major cases that I would like to touch upon related to this. So this is the imatinib case. I mean, the tyrokinase inhibitor, the receptors that are working at the cells is something that is at issue here. And Gleevec, the leukemia treatment, the leukemia drug, is at issue. The first one is the Gleevec. And the second medical use is related to the autoimmune disease, which is the GIST, and that was registered as the patent is registered for the second medical use as well, and there was a validity proceedings, and the IP High Court said that it is a patent because of the inventiveness, but then the Supreme Court held that it is invalid because it lacks inventive step. And as you can see, Gleevec does have the c-KIT genes, and it is inhibiting the activation of the c-KIT gene that is in the prior art. And the c-KIT gene, if there is an abnormal activation there, then it causes GIST, and that is a known knowledge. So from the Posita's perspective, the Gleevec is related to the abnormality of the c-KIT, and the c-KIT's abnormality is related to the GIST patients. So it could be actually considered like the ladder logic, and if you attach these two different logics, I mean, it is quite easy to come to the conclusion, the same conclusion. So the Supreme Court denied the inventive step of this invention. And there is a rather more complex case that's related to the pregabalin case, and we talked about it from the Japanese case and the UK case, and that was about the second medical use, and you talked about the specification requirements, but then in Korea, the key question was around the inventive step. So the inventive step was acknowledged in Korea, and the validity was maintained. And due to the time constraint, let me be very brief in explaining this. So the pregabalin is the patented invention, and there was a prior invention, which is the Lasemiche. And as you know, Lasemiche is like a mirror image. So the formula is the same, but then it is a mirror image of the original one, and the combination between the two is the lacemate, and one of it is considered the S isomer, and the other one I believe is a P isomer or something. And the prior invention was the two being combined together, and the patented invention was the two apart. So the structure is quite similar, but then there is a known information from the prior invention, which is GABA level. I mean, GABA levels of the brain, if it goes up in the brain, then it would have the antispasmodic effect. You will have the calming effect on your body. And secondly, it will reduce pain. So when the GABA levels go up, these two effects would be in effect, and the plaintiff argues as following. So the pregabalin is based on lacemate, and that increases the GABA level, and when the GABA level goes up, then it will have the antispasmodic effect. That's the prior invention. And the second prior invention is GABA level goes up, then the pain will be reduced. Then the lacemate increasing the GABA, that's one, and GABA treating the pain, that's the second. And if you combine the two, then that's a very simple logic. I mean, pregabalin would naturally have the pain-relieving effect. So that is like the GIST, case that we saw, and you may think that this is very similar to the earlier case, but then the Supreme Court ruled otherwise. First of all, lacemate increasing the GABA levels. The Supreme Court looked at other prior documents, prior literature, and it was not the case. To increase the GABA level, the GAD enzyme had to be activated. And we tested it at the cell. You increase the GABA level there, and when you connect it to the GE, then the effect was GAD, then it was not as active. So GABA level increase, is that really natural? I mean, that was still doubtable. So racemate having the antispasmodic effect, maybe not, that is not because of the GABA level increase. Then the three-level logic gets collapsed. And that is why the Supreme Court held that even though the GABA level has something to do with the pain treatment, maybe that GABA level is not directly related to the pregabalin. It is not clear, so that is why the inventive step is not denied. And I will be able to talk about this in more detail at the dinner time, but the three-step logic was not applied in this particular case, unlike the earlier one. And I would like to share with you two other cases from the Korean Supreme Court. And the Korean Supreme Court, when it comes to the selection invention, it talks about whether the combination is easy and how much of the effect it has. So the difficulty of construction or difficulty of the combination is something that they look at, but then for this one, they don't look at it for the selection invention, because when it comes to the selection invention, it's about selecting from a wider pool. So selecting may not be so easy, may not be so difficult. So the combination is not that easy. So it was only using the inventive, the other criteria to judge the inventive step. But then when it comes to the Apexaban case, it changed its view. It started to see that selecting from the pool in and of itself can be difficult. So in the prior art, to make it into an apixaban, A, B, D, G, we have many different factors there in the screen, and when it comes to the combination, a lot of myriads of combination will be going in that could actually result in like millions of combinations. And the Fusita, if that person is doing the trials and error, it will take a long time, and even if you're using a computer, it will still take a long time with a lot of difficulties. So even when it comes to the selection invention, you will not only look at the effect, you will also need to consider how many trials and errors one would need to go through and how difficult it is to make that combination. And that's sort of a legal, doctrine, or the legal principle started to be emerging in the Korean context as well. And another one is around crystalline invention or polymorph invention. It's like this, boiling the sugar. If you continue boiling it, it could becomes like the crystal, and then it will melt, and then it will become crystals afterwards. And identifying a structured or crystal formed material from that kind of a process is something that is related to this type of an invention. And in the past, the difficulty of composition was not really looked at in the Korean court. But then, even when it comes to the crystalline form invention, whether it is easily achievable or not is something that will still need to be looked at separately and thoroughly. And that was a change that took place in the Korean court. And I did, lay out some details in the booklet. But if you have any questions, among the panelists, then I would be happy to talk about them separately afterwards. Thank you.
예, 이지영 판사님.
Well, thank you for that presentation. With that,
3세션에
and we would have heard all the presentations as part 1, and part 2 is a Q&A session to one panelist. The remaining 5 panelists will pose questions, and we'll listen to the answers. We have actually passed a lot of allotted time. But so for the efficiency, we have already collected questions and distributed to the panelists already. So the questions will be put on the slides, and panelists on the prepared questions, if you could give a group of answers for 5 minutes, it would be appreciated, and then we'll get questions from the floor. Now, starting from Judge Amano, we have already sent you the questions, so we will give you 5 minutes. So please give overall answers to those questions, and we will pop the question up on the screen. Thank you.
Okay, just quickly, from the question from China, I already explained that the screening for monoforms are considered as a routine for the skilled person in the art. So generally claiming up some sort of crystalline is not have inventive steps. So just the kind of difficulty or effect is needed to get an inventive step. The next question from UPC is that about how we find the accused substance used for the patented use. It is very difficult. Therefore, in Japan, especially in pharmaceutical industry, courts tend to look at the package insert or a product monograph issued by Ministry of Public Health. It is called the label theory. When there is enough evidence that the defendant does not follow the instruction written in the package insert and uses the substances mainly for the patented use, the court may find infringement. Next question from USA about the recent change about enablement requirement. Although there are not any changes in enablement requirement, but striking a balance between patent protection and access to technology. IP High Court had welcomed many amicus briefs recently in the case where the Doctors Act or drug compounding is accused for patent infringement. The issue is the scope of Patent Act clause, which exempts doctors' liabilities. It is said that in Japan, there are not enough protection for doctors from patent infringement suit. So this case will be a trigger for the argument whether doctors should have more protection. From the question from United Kingdom, theoretically, if the products or compounds have survived the scrutiny of novelty or obviousness, the claims product or compounds are protected as themselves. So the Japan Patent Office does not require applicants to claim up its inventive contribution to a claim if the claimed product is useful, novel, and non-obvious. However, in most cases, the examiner makes first action of refusal for novelty or obviousness for inventions for compounds itself. For the question from Korea, for the secondary use inventions, Japan Patent Office requires at least one working example supporting medical use. As I explained in the Warner-Lambert case, to clear support requirement and enablement requirement, applicants sometimes have to disclose enough examples which enable skilled persons to understand that the secondary use is really effective and could solve the problem. I didn't find any criticism to this practice. That's it.
예, 아마노 판사님, 예, 감사드립니다.
Thank you very much. Now, moving on to Judge Fu. Again, 5 minutes, please. So all the questions that you have received, if you give collective answer, thank you.
Okay. The first question is from Japan. And this question is for my second case. Regarding a fast-track channel, currently, there's no relevant expedited processing procedure in China. If the patent's validity is later upheld, the patent holder can still file a lawsuit and get protected accordingly. And the second question is from UPC. I indeed cannot predict whether an anti-suit injunction will be issued in the field of SEP, as it depends on the specific circumstance of Chinese law and its judicial practice. And next question is from USA. My answer is yes, as you mentioned, chemical compounds cannot obtain utility model patent rights, but equipment used in the manufacture or processing of pharmaceuticals can be protected as a utility model patent. And next question is from UK. if a pharmaceutical patent is valid and infringed upon, the court should analyze whether the plaintiff claims can be supported. For method patents or product patents in the field of pharmaceutical, the content of the injunction may vary, as they protect different kinds of technical solutions. And the last question is from Korea. Before this amendment to the patent law in 2020, China already had patent validity confirmation lawsuit in patent litigation. This pharmaceutical patent linkage litigation introduced confirmation lawsuit into the specific field of pharmaceuticals. Thank you.
네, 부판사님, 예, 감사드립니다.
Thank you very much. Now moving on to UPCs. Judge Haedicke, again, 5 minutes. If you could answer all the questions together, which you have already received. Thank you.
I read in my travel guide that Korea is famous for very good new glasses. I should have taken the advice and bought new glasses, because now I cannot really read the questions, but I can guess the questions. I remember them also. So thank you for the helpful. Okay. So I think some of the questions focused on the problem-solution approach, and as I said in my presentation, it's still open which approach we take. I can maybe give a very brief overview of the differences between the problem-solution approach and the German approach. The problem-solution approach identifies the state of the art within the invention and looks at the document which is closest to the invention. And the German approach defines the problem in a more open way. It is not determined with a view to the invention. The approach determines the technical problem and does not mean to compare it with the solution. So the starting point is different. What are the differences? Well, they are not so big as one might think, because the German law requires for inventiveness that there's a pointer in the state of the art next to the EPO applies the could-would approach, which also requires promptings. What are the differences then? There's a certain danger that the EPO approach uses hindsight in determining the state of the art. The technical problem of the EPO is more difficult to be formulated in such way to avoid that certain elements of the solution are already implemented. And maybe the German approach is also more open in the sense that the problem is formulated in a more general way. It is not narrowed in the sense that there would be a technical problem which requires a technical solution. So the problem could be vaster and could be diverse, maybe to make the product more attractive or more marketable. And finally, the German approach reflects the situation of the inventor, who does not necessarily know into which direction the invention should go. But these are dogmatic differences. In practice, as I said before, I think the differences are not that big, and there are where we need to wait and see how things develop in the UPC. I can't say anything more about that. What issues have emerged during the rollout of the Unified Patent Court as pharmaceutical patents have been addressed? Well, I think we don't have so much special pharmaceutical patent issues because we have these 2 or 3 cases, and I talked about those. And I can use this opportunity to make publicity for the Hamburg division. Judge Klepp has a chemical background, she's a chemical engineer, so we are certainly able to deal with chemical patents. The problems we have, I think, are more of a general nature, like the case management system is a problem, and we need to establish and get our things together there too. I think Judge Lee's the decision question I already answered it because for the problem solution approach. And let me see. I think I'm through with the questions. I think that's it. Thank you very much.
예, 헤디케
Well, thank you very much, Judge Haedicke. Now we'll move on to Judge Jordan. Please.
Okay, thank you. Beginning with Judge Amano's question from Japan. He asked, in the Restore Patent Rights Act, are there any added requirements to get an injunction? And the answer is no. But I think it's important to note that the aim is to the contrary. It's to try to make getting an injunction easier, not harder. And if they're successful in getting that passed, that will restore, as you might notice, by the way, that it's a habit in the United States for Congress to try to come up with clever acronyms. RESTORE stands for Realizing Engineering, Science, and Technology Opportunities by Restoring Patent Rights Act of 2024. Yeah, all of that to try to say restore. We want to get back to pre-eBay law. What are the chances the bill will get passed? Boy, that's so hard to say, but I will tell you that this has got more bipartisan support than most any legislation in the patent arena that I can think of in the last several years. There's lots and lots of support on both sides of the aisle for getting it done, so I'm relatively hopeful that that one will get passed, and I don't think that the presidential election will affect a fate of that bill either way, because I don't think either it's not really a Democrat or a Republican issue. Judge Haedicke asked, do you expect consequences of the presidential election on pharmaceutical patent law? And the answer is, yeah, probably not. It's a little difficult to say, but these are the dividing line really in the U.S. Congress, I think, and I don't pretend to be an expert on this either, but I think the dividing line is probably the same as it is in many countries, and that's between the technology industry's interests and the pharmaceutical industry's interests. They have very different takes on how stiff they want the patent laws to be, and that's not so much right or left as two strong and well-heeled industries lobbying Congress. I would say that historically there's been more interest in the Democratic Party, more willingness to give directions to pharmaceutical industry or to tech industry, then there's been maybe an appetite on the Republican side. But the party's positions on these things are in flux as there's a great realignment underway in the Republican and Democratic parties in the United States. In what sort of circumstances, Judge Meade asked, might it be likely that injunctive relief would still be refused under the Restore Patent Acts? And I'm guessing that the answer to that is in a case much like the one that motivated the eBay case to begin with, and that is you've got a non-practicing entity, a patent assertion entity that's pressing its rights with respect to a patent that has very significant publicly significant effects. You could see that happening with a drug. You could see it happening with at the time a BlackBerry, an important technology patent. I could see something like that coming up again. And finally, Judge Yi asked, and I hope you've had a chance to read this. It is a detailed and important question, but it gets to the issue of what had been called the antibody exception in the Patent and Trademark Office with respect to whether or not you could get a broad genus claim with functional claiming, and the Patent Office had said well, you could do that with antibodies because there's really no, we don't really understand the structure very well, so go ahead and do it that way. That was sort of the gist of it. And that got deep sixth. The Federal Circuit really tightened up the enablement requirement with respect to biopharma patents, maybe with the Lilly case back in the late 90s, and then with the Janssen, AbbVie versus Janssen case back in 2014, I think it was, and they did that on the basis of written description, not on the basis of enablement. And then tightening up things on the enablement side in Amgen versus Sanofi, which, as I've said, the Supreme Court went ahead and affirmed. So, yeah, that's gone, and I don't think that antibody exception is coming back. There's not a real good answer to that right now. This is going to have to get worked out over time. If we had more time, I'd be interested to have a discussion on this panel or with any of you about how to get the right balance between requiring more in the way of enabling disclosure and not wanting to clamp down on a field of art which has such promise, and it is so difficult to give the kind of structural disclosures people are used to getting. That's not an easy set of tensions to navigate.
예, 조든 판사님.
Well, thank you very much for that answer. Now we'll move to UK. Judge Meade, you have the floor.
Thank you very much. Judge Fu and Judge Yi have asked related and overlapping questions. Judge Fu asks about the differences between UK law and EPO case law and how we balance them. And Judge Yi has asked a question about G2 of 21. And I've touched on quite a lot of this already in my main presentation. We try to balance these differences by ultimately following EPO case law as closely as possible whenever we can. But those decisions have to be made where it involves changing UK case law, either by the Court of Appeal or by the UK Supreme Court. And I'm a first instance trial judge, so as the expression goes, these questions are above my pay grade. They will have to be resolved by the appellate courts. I would say this, one cosmetic difference between the UK and the EPO is that we don't use the problem solution approach. But our case law has consistently said that there should be no difference in the result between the approach we use and the problem solution approach. And the EPO adopts the problem solution approach for practical and procedural reasons, partly. And both the EPO and the higher UK courts have all said that the ultimate statutory question is simply whether the invention is obvious under Article 56 of the EPC. So it's important, I think, to notice that some of the differences between the UK and the EPO, or indeed the German courts or the UPC and the EPO, are more presentational than real. And it would be a disappointment to us in the UK if we ever found ourselves in the long run applying different law from the EPO. We very much want to be the same, and in due course, I'm sure, albeit in a slightly different context, we will be giving very close and careful attention to appeal decisions from the UPC. Judge Haedicke asks a question by comparison with the UPC Munich Local Division in 10x Genomics about the standard of proof applied by the UK courts for the grant of a PI, a preliminary injunction, an interim injunction. And he asks whether we apply the preponderance of evidence test. The answer is that the UK courts don't apply the preponderance of probability test for interim injunctions. For final injunctions, for final trials, we make our decision based on the ordinary civil burden of proof, more likely than not. But for interim injunctions, the UK simply determines whether the patentee has an arguable case and whether the defendant has an arguable defense. And if they do, then we decide whether or not to grant an interim injunction based on the balance of justice, which is probably a familiar concept to you. But what I mean by that, just in case there's some issue over the translation of the language, what I mean by that is the court asks itself, if I grant an injunction and then it turns out at trial that I should not have done that, can the defendant be compensated? Or correspondingly, if I refuse to give an injunction and then it turns out at trial that there should have been one, will justice be done, can justice be done to the patentee? So for interim injunctions, the balance of the burden of proof is not very important, and it simply requires that there's an arguable case on both sides. And then lastly, Judge Jordan asks, in the US, there are occasionally antitrust claims brought against pharma companies for patent thickets, and do the UK courts have similar cases? The answer is, in the European regime, there are similar situations. For example, with pharma companies deliberately misleading the patent office to obtain a patent to prevent generic entry, or in one instance, by manipulating the patent owner's own marketing authorizations to delay generic entrance. And in both those situations, which in fact arose in the same case, the pharma company was fined a very large amount, in the hundreds of millions. Those have not claims that have generally been litigated in the UK courts as private claims. They've been antitrust investigations by the competition authorities in the EU. Post-Brexit, our own competition authorities have the power to do that, and I'm sure will in the right case, and theoretically there could be a private law claim, but actually it's very rare, and certainly very rare for them to be successful.
예, 미드 판사님, 예, 감사드립니다.
Thank you, Meade. And lastly, I would like to ask Judge Yi to go ahead with her answers.
일본 판사님 질문에 대해서는 구성의 곤란성만으로 진보성을 판단한 결정형 사례는 없습니다. 그래서 타일로시 판결 이후에 선고되었던 대법원 판결인 셀렉스팍 1형이나 미라베그론 알파형 결정의 진보성에 대해서도 구성의 곤란성뿐만 아니라 현저한 효과 여부까지도 함께 판단했다라는 점을 말씀드리겠습니다. 중국 판사님 질문에 대한 답변으로는 이제 청구범위라든지 특허 청구 범위에 맞는 데이터인지를 확인하는 방법은 결국 당사자들의 주장과 당사자들이 제출한 증거에 의해서 판단할 수밖에 없는 것 같습니다. 일방 당사자가 낸 증거에 의한 청구 범위를 인정할 수 없다라고 한다면 그걸 주장하는 당사 반대쪽에서 합당한 반증을 제출을 하면 되는 것 같습니다. 관련해서 당사자의 주장과 증명만으로 부족할 경우에는 민사소송법과 특허법이 규정하는 전문가 증인 제도나 감정 검증을 통해서도 확인이 가능합니다. 실제로 특허 사건에서 직접 재판부에서 검증을 통해서 이것이 효과가 있는지 그 권리 범위에 속하는지를 판단했던 사례도 있다고 저는 들었었습니다. 그래서 그런 방법으로 판단이 가능하다라는 것이고, 또 제출된 데이터의 신뢰성에 대해서도 같은 방식으로 확인이 가능한 것 같습니다. 그리고 데이터가 조작이 되거나 위조 변조된 사례는 사실은 거의 없었던 것 같습니다. 일단 제출된 증거 자체는 거짓이 없으나 그 증거가 주장과 합당하느냐의 문제만 남기 때문에 결국은 법관이 자유심증으로 판단할 사안이라고 생각을 합니다. UPC의 질문에 대해서는 이게 한국에서는 매니피스트 어레인지먼트라 불리는 법리는 없긴 합니다만 2차 용도에 대한 권리 범위 파악은 굉장히 중요한 문제라서요. 그래서 한국에서도 이와 관련된 프레가발린 침해 사건이 있긴 합니다. 그래서 이게 이제 잘 아시다시피 풀 라벨과 스키니 라벨의 문제입니다. 한국 발음으로 라벨이지만 번역하실 때 레이블이라고 해주시면 될 것 같고요. 그래서 결국은 용도 특허에 대해서 2차 특허는 유효한 것이고 1차는 특허 효력이 없다고 하면
If there is no such a thing, then in terms of the generics, I mean, the first medical use only would be registered for, and on the label as well, only the first purpose will need to be put in, and using the skinny label to confirm the relationship related to the rights is something that we do. And when it comes to the skinny label, I mean, the infringement was not acknowledged in the full label. I mean, this infringement was acknowledged, and we do have such a case. So
특허가 있는 부분에
So even when you receive the label, excluding the patented claim, I mean, if the doctor uses it for the second use, I mean, can we actually hold the pharmaceutical company liable? I mean, in Korea, it is structurally a bit difficult because in Korea, the prescription is based on the product name, not based on the substance name. So the same substance used for other purposes is not easy. And second thing, I mean, you can also use the item authorization system, and if you don't use that system, the doctor cannot be paid. That is based on the national health care or national health insurance system. So there is not many cases where the doctor would be, intentionally using the substance for different purposes. And to answer the question from the U.S., I mean, we did deny the AI as an inventor through the Davos case decision, but using the AI for the development, I mean, that is widely used in the private sector based on my knowledge. So when they are identifying the second medical use, I mean, they would usually in the past conduct the direct cell, diagnosis and stuff like that. But then these days, I mean, they're using the in silico docking and other methods to identify the second medical use. But when they are filing for patent, how much of the specification writing should be done would be an issue, because the device that you use will need to be written down in the specifications to find the second medical use. So when it comes to the AI-based pharmaceutical R&D, I mean, we do not have many projects in place, but then recently the patent office in Korea started making research about this, so we will be able to see the results of such studies in Korea as well. And the last question from the UK, imatinib GIST case was mentioned earlier, and there is a clear statement from the Supreme Court. The effect of the treatment, if that can be easily predicted from the prior art, then regardless of the clinical trials, the inventive step would be denied. So the success rate of the clinical trials and the inventive step are considered not related, and I think the hurdle was considered low in that case. Thank you.
이정 판사님, 감사드립니다. 이로써 저희 세션에서 준비한 공식적인 발표와 답변 순서를 모두 마쳤습니다. 패널분들께 감사드립니다. 저희도 조금 힘이 빠지고 이제 저녁 먹을 시간이 돼서 다들 피곤하신 것 같은데 박수 한번 부탁드리겠습니다. 그러면 혹시 시간이 많이 지났습니다. 저희가 늦게 15분 정도 늦게 시작을 했기 때문에 저희가 예상 시간보다 조금 늦었고 지금 거의 약간밖에 안 돼서 늦었습니다. 어쨌든 시간이 많이 부족하지만 혹시 플로어에서 오늘 각국에서 오신 패널분들에 대해 발표 내용에 대해서
If on the presentations, if you have any questions, although we are behind schedule, we'll be more than entertain any questions that you might have because we finished all the official proceedings that we had. And the applause was to encourage the panelists for staying until the end, and that you must be tired. So no microphone, because there seems to be a question from the floor. Maybe Judge Han, you could deliver the microphone to the one that want to ask the question.
Thank you for the enlightening speeches. I'm sorry. I know that everybody is tired, but I was so desperate to ask this question. I want to pose a question to Honorable Judge Jordan on Amgen versus Sanofi case. Actually, I read the case right after it was published, and it was with my colleagues in IP High Court. And afterwards, I read numerous articles and comments blatantly blaming this decision. Like, for example, saying cataclysmic shift, or two-bladed Fujita killing innovation, assuming the less skilled Fujita in prosecution phase and at the same time omnipotent Fujita when invalidating patent. And it seems that from outer, and you've mentioned on Restore Patent Rights Act, and it is getting bipartisan support. But I wanted to ask if what the atmosphere is like in the court among judges on this this decision, and if whether there is a different perspective in the business. And I want to add one more thing. As a person having extraordinary interest in artificial intelligence, I thought that this Amgen versus Sanofi case could be a useful tool in AI era, because in AI era, generative AI can generate like fake inventions very much, and I think enablement requirement could be the real linkage between the patent, linguistic patent, and the real world. And if you could comment on this thought, or I would be also be thankful if any of the speakers could add on or share your thoughts on this issue. Thank you.
Sure. The decision has generated some controversy because and some of the controversy was of the sort you just mentioned, which is people saying, "Oh, look, you've made it impossible for us to incent into innovation in the biologics space because." Nobody can really talk about the structure adequately in the way they can when you're talking about small molecule drugs. It just doesn't match up. And so you've created, in fact, there's a well-known professor at Stanford named Mark Lemley, and he and another fellow wrote an article last year, I think it was, called the patent, the antibody patent paradox or something like that, discussing this point and suggesting that that the traditional applications of enablement were not adequate to provide the kind of incentive that you want in this space. But there's been pushback on that by other academics and by some practitioners, because they've said, look, the very fact that structure and function are not tightly related to each other in biologics the same way they are with small molecules tells you that if you give broad claiming power, you're going to actually retard innovation. You're not going to incent it. And you know that because they say, and this I take this stuff in and I repeat. I'm in the Justice Scalia camp. I got to learn it all in each individual case. But the assertion is that with very little change in structure, you can have an enormous change in function, and by giving broad coverage, you prevent important advances, and we don't want that to happen. And I don't know how that's going to shake out. I really don't. All you have to do is look at the lineup of the amicus briefs that were filed in the Amgen versus Sanofi case to see that major pharmaceutical companies lined up on both sides of that. I wrote it down because I thought it was interesting. AbbVie, Bristol Myers Squibb, and Merck all came in for Amgen. Pfizer, Eli Lilly, Genentech, and AstraZeneca all came in for Sanofi. And when all those guys can't agree with each other, you know there's an issue, right?
예, 답변 감사드립니다.
Thank you for your answer. I think time is up for today. So this is the end of the session 3. But before we finish, I would like to give maybe 30 seconds to 1 minute to all the panelists to have a closing remark. So starting from Judge Amano of Kenji.
Okay. All right.
I'm glad to here today. Thank you for inviting me to the conference and memorial conference of 10th anniversary. When I was very young judge, I was eager to become an IP specialized judge. And in 2009, I went to the United States. And 2011, I went to the federal circuit and go to the then chief judge leader. And I spent several weeks in Judge Leader's chambers. So today, I have the opportunity to speak with former Judge Leader. It was very wonderful time for me to see and speak with Judge Leader. Even though my answer to the doctrine of equivalent is different from his answer, but I was very glad and very nice to come here today. And thank you for very organized conference made by every staffs and judges of IP High Court. Thank you so much.
자, 이어서 중국의 푸 판사님.
We'll hear from Judge Fu from China.
It's my honor to be here. Chinese courts place great emphasis on the pharmaceutical and biotech. In this session, I learned many experience and judicial practice from the judges from different countries. I think this will make me and make us improve together. And I am also looking forward to the upcoming session. Thank you.
네, 감사드립니다.
Thank you.
UPC의
Thank you very much. Now, Judge Haedicke, please.
I teach a patent law class at my university every year, and at the university, patent law is looked upon as something very strange. Are there really lawyers or are there technicians? Do they know what a contract is and so on? But when I teach this class, each time I tell my students, what we do is one of the most important things at all, because we secure innovation. We are the ones who protect the future, who create the future, because we are the ones who don't protest and are anti-technology, but we are trying to develop life further. And I think this is very, very important, and especially meeting at such a high-level conference, talk about these important things, is something I really, really appreciate. I want to say thank you again for having me here and for giving me the chance to listen to all these very interesting presentations. Thank you very much.
예,
Thank you very much. Now, let me invite Judge Jordan.
I had the chance to participate in this conference in 2020, but that was the COVID era, and it was just remote. And I just want to say how much more I like being with you in person. You're all a lot better in person. Virtual's good, but the socializing, the chance to visit with you, the food's a lot better in person too. So many, many thanks for the opportunity to participate with you. This has just been a wonderful conference. I'm looking forward to tomorrow.
네, 감사합니다. 이어서 영국의 미드 판사님 말씀.
Yes, Judge Meade, your turn.
Thank you very much. Many of my fellow panelists have said how wonderful the organization of this conference has been, and I fully agree and express my thanks as well. I would say in relation to the two sessions that I've been on, especially how extremely useful it has been to have such detailed materials in advance of the sessions to think about matters before the sessions, and I thought having the questions before this session was especially thought-provoking. I'd also say I'm lucky enough to go to quite a few judicial conferences, and I often am lucky enough to be able to interact with judges from Europe, the UPC, and the US. But this is the first conference where I've had the chance in person to interact so much with judges from the Far East, from Korea, from China, and from Japan, and that has been an especial highlight for me of this conference. So thank you very much to the organizers for those things.
예, 네, 감사합니다. 마지막으로 한국의 이정 판사님.
Thank you, Leslie Daji.
주제 함께 해주셔서
Thank you so much for being here with us to follow up with the really difficult topic, moderator, panelists, and all the audience members for staying with us until the end. Attorneys and the judges, practitioners.
예, 감사합니다.
Thank you. This concludes the third session. This is an important topic to extend the life of all of us. I mean, of course, patent is really important in that aspect, but then having a great dinner is going to be the most important factor. So let's enjoy lunch now. Dinner now. Thank you.
발표를 진행해 주신 연사
I would like to thank the moderator and also panelists for their efforts. So let's thank their efforts with warm round of applause. And with that, we would like to bring the day one program of this conference to end. I would like to thank everyone for staying with us until the end. And tomorrow we'll start at 10. So enjoy your evening, and I'll see you tomorrow. And those that are attending our dinner, we will start as scheduled at 6:40 at this